Now, before we get to today's episode, here's a quick word from Josh about an upcoming event that you don't want to miss.
Anora, thanks very much. Hello, everyone. I'm Josh Sovin. I'm an antitrust partner at Paul Hastings in Washington, D.C. I, along with Jeremy Gunn, are the co-chairs of the upcoming Antitrust in Healthcare Conference, which will be held on May 20th in Washington at the Martin Luther King Library. We are very excited to offer what we think is a different and unique approach to competition policy in healthcare. We will, of course, cover all of the standard antitrust issues that have been with us for many years, but we also want to broaden it out to a much more holistic perspective on what's really going on in the healthcare markets. To fulfill that objective, we're going to kick it off with Peter Orszag. He is the CEO and chairman of Lazard. He is going to offer a perspective from the financial community about the role of the healthcare markets in the U.S. economy, how it affects the employment sector, of course, how it provides healthcare to people throughout the country, and what are the next steps to ensure that the healthcare markets continue to function efficiently. We'll also hear from a number of enforcers. We have various heads of the antitrust components of the state attorneys generals who will appear. Rohan Pai, the head of the Mergers 4 group at the FTC, will also talk about what's on his mind. In addition to traditional sort of in-market mergers, he will cover cross-market mergers and other non-traditional forms of combinations. And then we have a fantastic group of economists and lawyers. We have a very distinguished panel of academic economists who have written about healthcare markets in a very accessible, tangible way. We'll also have a panel of consulting economists who are appearing before the antitrust agencies on a regular basis. And then we will finish it up with 4 of the best litigators in the country who have handled the most demanding enforcement actions brought by the agencies over the last couple of years. We really are looking forward to everybody joining us. It's a big group that has already signed up, and we welcome others to attend. Thanks very much, and look forward to seeing you on May 20th.
Fantastic. Thanks, Josh. May 20th. We'll see you there. Now back to the show.
Welcome to our Curious Amalgam, the weekly podcast brought to you by the Antitrust Law section of the American Bar Association. Our Curious Amalgam explores the fascinating and increasingly overlapping world of competition, consumer protection, data protection, and privacy law. Each week, we bring you leading global experts on the most compelling issues of the day. Enjoy the show.
Hi there, and welcome to our Curious Amalgam. I'm here at the 2026 spring meeting with Luke Woodward, who's a commissioner at the Australian Competition and Consumer Commission. Luke, welcome to the show.
Thanks very much, Lexi.
So we're very excited to hear about some of the new developments in Australia over the last 12 months, but I thought we would kick things off with a more general question for our audience. Australia has a somewhat distinctive model when it comes to combining competition and consumer protection under one agency. So I'm very curious to know how this combined mandate you think influences your approach to competition regulation.
It's a great question. It's part of the design of our agency, combining competition and consumer enforcement, consumer protection, and our overall objective is to promote competition and protect consumers across Australia. We see that very much as an integrated objective. Competitive markets are ones that are going to deliver, innovation, productivity, growth, great products and services at, affordable prices. They need to be free from, business restrictions, collusion, exclusion, but they really also need to be ones where consumers have high degree of confidence and trust. If consumers are tricked, that hurts them, but it hurts the traders who are trying to do honest business, and it hurts the overall competitive market. So we do see it in a very integrated way. If I give you a couple of examples.
Please.
In the supermarket sector in Australia, it's very concentrated. We undertook a market study looking at the competitive dynamics of that, and we found that there were kind of oligopolistic patterns of competition there and high margins. And we have subsequently taken actually 2 consumer protection cases. One was just been to trial and one's about to come up in relation to deceptive discount practices where we allege that each of those businesses actually substantively increased their prices, but in the way in which they'd done it, they tried to present it as a discount. And we say that misled consumers. Now, court will have to evaluate that matter, but that obviously causes consumer harm, but importantly, it harms competitors who are actually trying to get across the message that we have a good value discounted price if other traders are misleading people about the true, genuine discounts. So that's one example. Another example would be in the aviation sector. We have a highly concentrated aviation sector, and aviation is very important in a country the size of Australia, with dispersed population, where family and friends need to travel around the country to connect. Business needs to do that. Travellers and tourists need to do that. And we had a case against our national carrier where what they were doing was selling flights on or selling tickets on flights that they had already cancelled. So we took that action. And obviously that caused significant consumer harm because they obviously put people on alternative flights, but that disruption often caused significant cost. But what it also did is it robbed the competitor of the opportunity of selling that flight that the consumer would have wanted at that time and on that day. So they're two good examples where we see a real intersection of consumer protection and competition.
That's very interesting, Luke. I guess sort of a follow-on question is those are some of the priorities for Australia at the moment, and many economies around the world are being asked to engage more directly in questions about market structure, productivity, consumer outcomes, not just individual cases like the ones you're describing. Yeah. So do you see that as a natural evolution of the role of enforcement and the cases you're talking about, or a response to how markets are changing and working?
It's possibly the latter, but I do genuinely see it as just a natural part of our role. I see it as being highly complementary. We do have different market studies and monitoring roles that the government has given us. They're important because they allow transparency into particular dynamics that are happening in markets. They're also important because they can kind of drive our intelligence, and we can and allows us to maybe identify where there might be consumer practices or practices that unfair trading practices or competitive restraints. And we can, that might build into guidance, it might build into law reform, or it might follow into enforcement actions. So, and I do think our agency is just well placed there. We have a depth of understanding of how markets operate, just by nature of our role. We've got very, very experienced case handlers who are specialists, have special knowledge in a lot of markets, but even in markets where they don't, they've got the depth of understanding to analyse markets. We've also got strong and deep economic expertise and lawyers, and we've got great data analytics. So we're well placed to do that role, and we have been called on by government to do it in a range of areas. Maybe some of your viewers will be familiar with the work that we've done in the digital platform or digital services area. Another example would be our role in fuel monitoring. We have had a long-standing role there, and it looking at prices and costs, and it means that we have a real depth of understanding of our the fuel supply industry in Australia, and that's put us in good stead here where we with the global fuel shock, because it's allowed us to rapidly move to kind of weekly, highly granular, deep reporting in relation to kind of prices and costs, metro areas, rural and regional. And transparency at a time like this is important in terms of concerns around price gouging. It's also allowed us to identify some specific practices that are potentially restricting competition. We're looking closely at some matters that may involve what we would say or is potentially anti-competitive rationing of competitive independent fuel supply sectors into our rural and regional communities, particularly in relation to diesel fuel supply. that is so important for agricultural and farming. So that's an example where we have that role, and we've been able to. It's put us in the right place at the right time. Yeah.
I'm curious, as a follow-up question, given how topical fuel supply is right now, are you, if you can say, are you turning out to be a resource to other agencies in Australia who are reaching out for, that kind of information or those studies that you've done on fuel supply?
Yeah, well, I'd certainly say we're a part of the governmental response to that. I mean, our government, like I'm sure many governments, are looking very carefully at ensuring, fuel supply and managing through, this shock. And so we are part of that, and we're operating in a very integrated way with the government around that. And, we have a part to play. We're not the whole part, but yes, I certainly think that in a kind of collaborative, governmental response, we're part of that.
We like to think in Antitrust that we're the heart of everything,
yes.
But we're a part of a broader movement.
We know we're the heart of everything, but
So to shift gears a bit, we're also seeing a renewed focus in many jurisdictions around the world on deregulation as a way to unlock innovation, productivity, growth all over the world in many different countries. So what is the ACCC's perspective on this trend, and how do you see the ACCC's role in economic performance in Australia?
Sure. Look, it's a real focus of the Australian government in terms of deregulation, and it's interesting, and it's a great opportunity to come to the ABA and actually find out that the kind of issues in Australia are actually are playing out in many different countries, but we obviously have challenges in relation to productivity, innovation and growth, our high cost of living, and so they're big challenges for the government, and a deregulatory focus, in where regulations are stifling competition or are just driving costs into business is a real focus of our government. We would see our role as being highly complementary to that. We would say good competition policy is really hand in hand with that, and I'd say good competition policy and enforcement and regulation is probably actually one of the best deregulatory tools that's available to the government. Just to maybe kind of explain that, if markets are working well and they're delivering innovation and growth and they're inclusive for people, job opportunities, and they're providing good quality products and services at affordable prices, then they're meeting the needs of the community, and that's our job, is to really do that. I answered some of the earlier question, but if they're not, well then people will call for regulatory responses, and so us doing our job well, I think, is part of that. It doesn't give us carte blanche. We need to be thoughtful about how we approach our role. We are a law enforcement agency that gives us a strong position, and we know law enforcement of competition and consumer laws is very important, and at times that will involve taking cases where we are seeking significant penalties, but we know that is important in relation to particular conduct, and also obviously sends general deterrence. So we have to do that, and we do that, but it's not sufficient, and so we need to think more flexibly about how we can address harms. Sometimes it will be taking kind of enforcement action. Sometimes we'll be just focusing on how quickly we can kind of get to the heart of an issue and get a remedy. I'll give you two examples actually. One is in Google search. We had a bit of both. Last year, the ACCC settled a court action against Google in relation to the restrictions on distribution of alternative search services through Android devices, and there was Google admitted contraventions, and we got in Australia a very significant penalty, over $55 million. But importantly, and perhaps more importantly, we were able to obtain commitments not to remove those restrictions, but not to reintroduce those restrictions. There's a lot of detail to that. And then another example, I think, where we were prepared to kind of be more flexible about it was in relation to a settlement that we had with Equifax, obviously a very significant credit bureau business. Also has an income verification product, which is very important in lending markets. We need efficient lending markets where, income verification is a critical part of that. Online digital verification processes are critical. And we were deeply concerned that Equifax had entered into arrangements that basically locked up critical data from competitors. They resolved that issue with us. They unwound those arrangements and entered into commitments not to do that in the future. And we've actually seen competition come in. So that's a case of kind of being a bit adaptable in our approach.
Terrific. Well, I would love to chat all day, but we have one more substantive question for you today, which is, what is the single most important capability or tool? And I'm thinking here about, data, expertise, institutional design, whatever it is, that you think the ACCC needs to strengthen moving forward to try and keep pace with how markets are changing.
Yeah. Well, I'm sure I can't think of just one. It's very important, I think, for effective competition agencies to have a clear sense of purpose and high morale. You have to have deep experience and expertise, and we do, and we invest a lot in that. You have to be adaptable, and you have to have organisational resilience. I think we need to have a curious mind. We need to listen openly and need to be fact-driven. And ultimately, we need to be able to, and I would say we do, have a high degree of trust in the community, consumers and business, governments, media, courts. So they're all really base-level kind of important things. But if you force me for one, I will say data. And I think at two levels. One, in terms of data analytic capability, and we invest a lot in that, but we're very focused on that in terms of our forward strategic plan for the agency, and integrating AI. It's not just all about AI, but AI is kind of a critical capability there, and so that is a big investment there. The other area where data is critically important is actually just thinking about how we can measure the impact we're having in the outcomes. We need to think carefully about, are we meeting the objectives that we're there to meet? And so we're putting a lot of thought into how we can sort of track that through data. What ways can we actually kind of measure how we're performing? When we're performing well, we want to tell people that. It's important that the government and others know that we're doing our job well. But also, if we're not having the impacts that we want, we need that feedback loop. Maybe we need to do something different. So we're putting a lot of thought into data in that domain as well.
I'm not surprised you said AI, but I am glad that curiosity made its way into your response earlier, because I do think, and it's a theme of even the 2026 spring meeting that we're at, because antitrust lawyers often think of themselves as very curious people and as a big part of the practice. So I think that's always true in what we do. To wrap things up, we try to have at least one question at the end that's a little bit more lighthearted than some of the substantive questions we ask. And today, I would love to hear from you. If Australia were a guest at an international dinner party, who would it be? Would it be the loud person across the room? Would it be the person who hosted? What role would Australia play, you think, at this international dinner party?
Well, I think the Australian character is we're adaptable. So depending on the dinner party that you have in mind, we might turn up with a case of beer on our shoulder or a very fine Australian Chardonnay, a bottle of that, maybe two. So I think we're adaptable. We would like to contribute. So around your dinner party, around the table, we'll contribute to the discussion. We'll be serious, but maybe we might make a joke or two. We do take ourselves seriously, but we would hope not too seriously. We'll join in. We'll have a go. So at the end of your dinner party, when you're pushing the chairs back and you're cranking up the music, we'll be on the dance floor. We won't be the smoothest people on the dance floor, but we'll be there. And I think we're collaborative. So we'll at the end we'll help you, clear up the table, and we'll be in the kitchen. We'll be packing things up and helping with the dishes.
You sound like pretty good guests to me.
Well, thank you.
Well, Luke, this has been a lot of fun. Thank you so much for being on our Curious Amalgam today, and hopefully we'll get to chat again soon on the podcast.
Yeah, thanks very much, Lexi.
Hi, welcome to our Curious Amalgam. My name is Anora Wang. I'm here today with a special guest who is Luke Becker, the Chief Legal Counsel of Competition at the New Zealand Commerce Commission, where he leads legal strategy and the litigation for the agency's competition enforcement work. Luke advises on complex investigations and court proceedings under New Zealand's competition laws, supporting the Commission's mandate to promote competitive markets and protect consumers. Welcome to the program.
Oh, great to be here.
Luke, so tell us a little bit more about your agency, other than what I just said, because people might not know that much well about your agency and even the abbreviation of it, which is NZCC.
Yeah, the NZCC, so the New Zealand Commerce Commission, and that's an independent Crown entity. And we actually have quite a broad mandate. And so we cover competition, which is what I focus on, but we also do consumer protection, regulatory functions as well. We regulate electricity lines, water, and other areas of that kind of the market as well. But focusing on competition law, we have kind of four main functions. So we've got mergers and authorizations, we've got cartels, market studies, and then lastly, unilateral conduct or competition investigations.
Sounds like a regulator and also an enforcer.
And yeah, exactly, it's both.
Right. So would you, and I don't know how long NZCC has in operation. If I do know, I would have told, but you would be in a better position to tell our audience.
Yes, like 30 years, over 30 years.
30 years. So 30 years in and going. And within the past 12 months, what have been the NZCC been busy with? Perhaps you can highlight some of the achievements that you're proud of.
Yeah, sure, happy to. So in New Zealand, we criminalised cartel conduct in 2023. So it's quite a recent law change. And we were very happy to have our first cartel enforcement decision last year. So that's in 2025. And that was in relation to a public procurement cartel. And they got a custodial sentence for that. And that was quite a big achievement for us, because when you get the new law, you want to kind of use it and test it. And having a win on the board for that was fantastic. And then I thought one other thing I'd highlight is we've had a lot of recent merger decisions, and a few tricky ones, including 2 declines. And one of the declines has been appealed through the New Zealand court system. And that was quite an important one for New Zealand because it related to our grocery sector, which in New Zealand is very concentrated. It's a duopoly. And so I think it's quite focus in the New Zealand media and for New Zealand consumers, because grocery prices are front of mind, as they are everywhere in the world at the moment. But I think it will be an interesting decision. Because it relates to acquisition markets and buyer power in acquisition markets. So it's definitely one to look out for when we hear from the courts.
Yeah, and I would say we have been doing these interviews with other enforcers from other jurisdictions. It sounds like, sectors that's close to people's actual daily lives.
Yeah.
And, cost of living is very, very important and sort of focus of enforcement as well. So we're sitting here at early part of 2026.
Yeah.
Perhaps you can tell us a little bit about the priorities of the agency in the next, perhaps 12 months?
Yeah, sure. So we publish our priorities every year, and some of our priorities are enduring. So they're kind of every year you kind of expect them to be there. They're along the lines of cartel conduct and protecting vulnerable consumers. And then some years there's a particular focus on certain areas, and they're a bit more short-term priorities, which for us has been a recent focus on anti-competitive non-competes. But a big focus for us, which you would have seen in the criminal cartel case, is public procurement cartels. Public procurement money is very important money spent by the government, and we're seeing a fair bit of activity there around public procurement and cartels. So that's a real focus for the Commission at the moment.
Sounds good. So with the ongoing Commerce Act being reformed, I guess the reform is aimed at strengthening merger control, addressing predatory pricing, and modernizing, I guess, enforcement tools.
Yeah.
Perhaps, how do you see these changes reshaping, I guess, the Commission's enforcement?
Yeah, it's a good question. They're not enforcement focused per se. I think the government looked at our powers and looked at kind of our highly concentrated markets, especially within mergers. And they thought there's some unclear rules, there are delays, and there are streamlined efficiencies that we could benefit from. And so I think there were two main changes I thought I'd highlight today. The first one relates to merger control. And there's quite a few changes in merger control, but I think they can be bucketed under streamlining the process. So there's now going to be faster, more transparent merger regime where there's actually a maximum days. So it's 140 days for a clearance for the full kind of phase 1, phase 2.
Is there any stop the clock mechanism?
That is still going through Parliament, so we need to see where that comes out.
Okay.
But there's currently in the current bill there is a stop the clock.
But it's good to have like a finite.
Yes, exactly right. It gives certainty for business. And New Zealand's a voluntary merger regime, but we previously didn't have call-in powers, and we're now looking to get call-in powers and a hold separate regime for mergers that are close to completing or have completed, which will be good. And then lastly, New Zealand currently we're not able to accept behavioural undertakings, and that's going to now be introduced, and we'll be able to accept behavioural undertakings, which I think has many benefits for the business community, but also when you're dealing with a multi-jurisdictional deal, in New Zealand's just one jurisdiction within that, it is helpful if we can adopt behavioural undertakings to deal with problems instead of having to only go with structural.
Yeah, sounds very exciting and definitely an area to watch out for. But timeline-wise, is these something that we should be looking out for in the next 12 months or longer?
Yeah, no, we should be. The law should come into force this year.
2026?
2026, yes. And then it's still been ironed out when the actual change will come into place, but I think within the next 12 months.
Sounds good.
One other change I was going to highlight was pro-collaborative exemptions, or there's a pro-competitive collaboration process where it's allowing businesses to come to us proactively and say it's in relation to RPM and buyer collective bargaining, and they can come to us, and when it's clearly pro-competitive, we can just bless that very quickly and allow businesses to get on with the work.
Right.
Whereas previously now it would have to be a formal authorization, which is much slower.
I see.
We're trying to unlock pro-competitive benefits for business community.
That's also business friendly. Yeah. Thank you for explaining that. So the Commission's current priorities, I guess, for 2025 through 2026 highlight both competition and consumer law enforcement. So I guess that includes misleading conduct and market power issues. So how do you balance these like dual mandates, I guess, in your practice? Yeah,
well, we see there's a real benefit to having both consumer and competition within our mandate, because when cases come before staff and before commissioners, we can decide what are the best tools to use. Is it more of is it better under competition law or under consumer protection law, or both? And often what we hear is happening in the consumer protection world actually may have a competition angle, and then you find stuff out that way. So we think there's a real benefit to that. We refer to it internally as a one commission approach, and so we try act as one commission. So while we have specialised competition staff and consumer staff, we're all within one branch, and we all deal with the same commissioners. And so we've got oversight of what's happening, and then we try to use a one commission approach to do what's best for New Zealand consumers.
It makes sense, because the business does business under the same roof. Why not law enforcement should be under the same roof?
Yeah, exactly right. Exactly right.
So looking ahead, do you anticipate any major, I guess, shifts or trends in terms of competition enforcement in your jurisdiction or elsewhere?
Yeah. I think we've already made the shift in recent times with the current commissioners. We are more clearly setting out our enforcement priorities publicly and then really actively chasing those and really focusing on those. So I think there already has been a big shift. One shift that's been talked about a lot this week is digital markets and what's happening there.
Right.
And in New Zealand, we don't have ex ante regulation, and that isn't on the horizon. So I think a focus for us is to use our traditional tools to continue to enforce in those markets where we see problems.
That makes a lot of sense. So we don't have a lot of time, and we appreciate you sitting down with us just briefly, but we still want to give our audience the opportunity to know you a little better as a person. So perhaps you can tell us a little bit more about any interest or hobbies you may have outside of the competition and the consumer protection world.
Yeah, of course. So I moved back to New Zealand about 6 months ago, and part of the big attraction for that for me was the outdoors. So I like fishing, hiking, and playing sport and all that. I play a lot of tennis, so I've been really enjoying getting back to New Zealand and getting out on the water and just exploring the country again.
Yeah, New Zealand is really heaven for all those activities.
Yeah, it's a good place to be.
Yeah. Oh wow. Maybe we'll have some interviews taken there next time in person, perhaps. Thank you for sitting down with us again, and thank you for listening.
Thank you for listening to this week's episode of our Curious Amalgam, a competition, consumer protection, data protection, and privacy law podcast. It is produced and shared around the globe by ABA's Antitrust Law Section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent their employer or other organizations. If you like what you heard or would like to become a member of the American Bar Association, please check out what the Antitrust section has to offer at ambar.org/antitrust. You can learn more about our podcast at ourcuriousamalgam.com. If you have comments, suggestions, or podcast ideas, please reach out to us at podcast@ourcuriousamalgam.com. Until next time, thank you for listening.